Well, hello everyone, and welcome back to Uncivil Law. And I'm joined by my friend and yours, none other than the late or the great, rather, Nate the Lawyer. He's not dead yet, but we love him.
Yes. What's going on, chat? Well, matter of fact, what channel is this one? This is your channel, so let me go
It's
check
on
it out.
YouTube. Yeah, it's on the YouTube
Let me
chat.
turn this on up a
Yeah,
little
so
bit,
we are here with
there
the
it is.
continuing coverage relating to the Texas high school track meet stabbing. For those of you who are unclear on the fact pattern, basically what we have at this point is we have a student who brought a knife with him to the track meet, and it's in his bag. He goes under a tent for a competing team at a track meet. His motivation is a bit unclear, but it looks like it was, sudden bursts of rain. That sometimes happen. Sudden rain, no rain. Sudden rain, no rain. And so basically what it seems like probably is true is that he went under the competing team's tent probably for the purpose of trying to get out of the rain, might be what he was trying to do. But the other team had an objection because this is our tent, not your tent. And then some words were exchanged. And then our guy with the knife, apparently what he did is he reached into his bag. He has the knife in his hand, it's still in the bag, and he says something like, and of course the exact words will matter, but something like, touch me and see what happens. Okay, right?
Would it be okay if I actually read it from the police report?
You absolutely can. Why not read it verbatim rather than me paraphrasing it? That's fine.
Yeah, only reason why, because I do think it's important. So it says,
You want to put this up on screen too, or you just want to read it?
Yeah, hold on. I'll put it up on the screen. Let me see. Up on the screen. Now I think I'm just going to have to read it.
That's fine.
Let me see. So from the police report, what he said, well, he said a whole bunch of things, but should I just read what the witnesses said? What the witnesses recounted?
Sure.
All right. So let me pull that up. Sorry. Now I got to look for the witnesses.
No problem. We got time.
So all this, and just so everybody understands, all this comes because we're having an argument, not an argument. We're trying to figure out.
We're having a learned discussion
about self-defense.
Yes. In Texas.
Yes. Oh, here it is. Sorry. I have so many things everywhere because I've been looking this thing up. So I have stuff here. All right. So the witness. This is the first witness from Memorial High. This is what they said. They said that Austin grabbed Carmelo to move him. Carmelo pulled out a black knife and stabbed him. So this is the first Memorial High School witness that police talked to. She said that Austin touched Carmelo, then told him to punch him. So he touched Carmelo. Carmelo then told Austin to punch him and see what happens. Austin then grabbed him to move him again. Then Austin went into his backpack and then said those famous words, touch me again and you'll see what happens. He then was grabbed again by Austin and he was stabbed in the chest.
So the way you read the police facts, there was physical confrontation before he reached into the back. Is that the way you're reading it?
Yeah. Let me put it up on the screen because I'd rather just have it so we can all see it.
Yeah.
Let me see. Share screen. Here it is. Share screen. Share.
Yeah. If there was physical confrontation before he reached in the bag, that would help him a lot in his potential defenses.
There was. He was pushed before. It says it here clearly.
Okay, then maybe I misread it when I read it on stream because I didn't remember reading that. But I could have misread it.
Yeah. Hold on. Give me a second.
I'm only human.
Let me do it this way. This stupid computer. But I can't do it that way because I can't search it. Okay. I'm trying to. It won't let me share. Oh, okay. Duh. Now it's gonna let me share the tab. Window. Which window? That window. Okay, share that window. There it is. All right. Now we're good. Now, Control F. I'm gonna just get to the part. Let me see if I can find it again.
Yeah.
All right. Austin said what happens. Here it is. So this is. Oops.
It's a little.
I know. I gotta make this bigger so we can all see it.
There we go.
And so this is what we are looking at, and it says Austin had told Anthony. So this is big Central High School Memorial. Yeah. Austin had told Anthony that he needed to move out from under the team's tent. So this is after the rain starts falling. Anthony grabbed his bag and opened it and reached inside and proceeded to tell Austin, touch me and see what happened. No one really thought that he was going. Austin proceeded to touch Anthony, and then Anthony told Austin to punch him. So here it is. So no one really thought that really had a weapon. So he was already.
Yeah, well, the way that's written, it's like it's written that he went into the bag before there was a physical confrontation.
There may be another one I'm talking about. Oh yeah, and Austin. So hold on. It says, "Touch me, sees what happens."
Yeah, but he
No one
grabbed
really
in the
thought-
bag
he
first.
grabbed-
That's
yes,
the way
yes,
it's
yes.
told
He
in
grabbed the
time.
bag first, and then there was another one where the witness said, "Hold on, I gotta find it."
Yeah, maybe a different witness had a different order of operations.
Let me
Which,
see
you know,
what this witness says. Come on, told him to punch. Yeah, maybe I'm mistaken because I remember reading it, but I gotta find it.
that's fine. Take your time. We're not in a rush.
That's true. Let me see. Let me Control F this. It was. See if I can find it. I should have had this ready. Let me see. Tell him really thought it was a weapon. No, you're right. I think. I don't know. I can't find it right now. I'll look for a while as we're talking.
Yeah.
I'm gonna have to read it again. But there was a part where there was like a little push and pull right before, and then it happened.
And then, of course, well, this witness says it was the other way around, and a different witness says, it was. Then, of course, it's just like what the factual picture here is obviously a little bit murky about exactly what happened. So, I mean, that's to be expected. Different witnesses are going to recount different things.
Yeah, before the argument, reached into his bag, pulled it up. Yes. Yeah, I gotta find that piece. But anyway,
all right.
So let's get to the imperfect self-defense. So I watched your mea culpa about self-defense. Now, so everybody understands when we say imperfect self-defense, generally self-defense has two elements that are required. There's an objectively reasonable element and a subjectively reasonable element. The objectively reasonable element essentially means that all of us would look at the situation and say,
the reasonably prudent person would think
yes. So we're saying, all of us, we kind of all agree that is the reasonably the perfect person. But versus subjective, where based on my personal feelings and experiences and all that, I would feel that this situation required this particular thing. So if I subjectively believe that is dangerous, where the force I'm using is appropriate, that's one thing. And then objectively, it has to be good. So, and a lot of times people kind of skip over the subjective piece of it and just go to the objective piece of it. But it's really two pieces.
I've at least heard of cases where people have lost on the subjective, which is hilarious.
Yeah, like they really didn't. It's like you really didn't now. But you can lose based on other knowledge. Like for instance, if you're a police officer, for instance, it'll have some specialized training. Then your subjective knowledge, it would be unreasonable to you, but objectively, it could be reasonable to everyone else because they don't have that superior knowledge. So you can't. That's one of the clear examples of that. But and when we're coming to imperfect self-defense, Texas recognizes it, but in a very, very, very unique way. And I'll go into the case law. The first case I want to talk to everybody about is called Evans v. State. And Evans v. State, it's a case from the 1980s. It's actually it is 1980. And I'll share my. I can't share my. I can share this screen. Yes, I can do this now. So I'm going to share my screen to show you the case.
There we go. Let's go to the law, baby.
So this is the case. Now, in this particular case, Evans was robbing a store. He went in to rob a store. And while he was in there with his gun robbing the store clerk pulls a gun out and shoots Evans. Hits him in the arm. He falls down. Now you're in a fight. Evans then points his gun at the store clerk, kills him. Boom. Right? Now he's sitting there bleeding. The guy's dead. The store clerk's dead. Evans is bleeding out on the floor. Cops come. Evans is charged with he's charged with not only murder but felony murder. So he's
capital murder.
He's looking at the death penalty.
Yeah.
As you can see from this case. So he's looking at the death penalty. So during his trial, his lawyers are like, all right, well, we got a little self-defense here. He was shot. The guy shot him. Obviously, Texas law doesn't allow. Says, no. He was in there robbing a place. He's in there with an armed robbery. The guy can defend himself. Self-defense isn't available to you.
Mm-hmm.
But then he said, well, all right. But in that particular instant, what was he supposed to do? He's supposed to let the guy kill him, right? He had to respond. He's literally, the guy's holding a gun over him. So the court said, well, this is a case of imperfect self-defense.
You got to love that. The guy who's committing the armed robbery still has
Yes.
a possible imperfect self-defense argument. This is great.
He does have an imperfect self-defense.
This is fun.
So the court said that the murder charge he cannot avoid. That's just something that his subjective belief of having a gun pointed at him and about to be fired, subjectively, yes, that would be self-defense, but that doesn't mitigate the murder. He's a murderer. He's going to get found guilty of that. But the jury has to be instructed that because of the situation that he was in, this could mitigate sentencing. And in Texas, the jury does sentencing. Remember the Amber Geiger count?
Is that the defendant's option? But yes.
At the defendant's option, yes. So in the jury instructions for sentencing should have allowed for him to argue this imperfect self-defense to mitigate the amount of time he's going to get. And the court reversed his capital conviction. He got life in prison, but they reversed his capital conviction at the end of this for that reason, because of this imperfect self-defense. See, so because again, they didn't give him the imperfect self-defense claim so he can argue it to the jury to mitigate his sentence. So I want to be very clear here. There's a difference. So now, when you in most states, they make it very simple. You can argue imperfect self-defense, and you can go from murder to manslaughter during the punishment phase of the trial. And then when you're sentenced, you'll be sentenced to manslaughter. But Texas does it in a very unique way. And the unique way Texas does it is you have no self-defense claim really available at the punishment phase, meaning the jury. They will find you guilty of murder. But if they find you guilty of murder, then you go to the sentencing phase, and you would say, hey, I want the jury to sentence me, which is your right in Texas. So now when the jury's sentencing you, you can essentially get 2 years for the murder if you then say this is an imperfect self-defense claim, and the jury is able to mitigate their recommendation for your murder sentence from before it was 5 to 99 years. If your imperfect self-defense claim is viable, that can turn from 2 years to 20 years in prison. But you would still be charged. Now you would still essentially have a murder conviction, but that murder conviction would actually be really the sentence would be a manslaughter conviction, but you would be convicted of murder. I hope I didn't just confuse everybody in the chat.
No, this is pretty good. And let me see if I can share a screen, because there's one part of it that I think that really speaks to what you're trying to say. So let me see if I can do this. Now, how do I actually do this? Okay, screen share.
But does the logic make sense here?
Yeah. Okay, so that worked. Excellent. So yeah, so this is the same case he's talking about. So we got this guy. Guy goes into the store to commit the armed robbery. The clerk pulls out a weapon. Our miscreant friend pulls out his weapon, kills the clerk, and he wants to argue it about at mitigation, that this mitigates his punishment in some sense. And so this is sort of where this issue seems to come to point. So the appellant, in this case, the criminal, the one who's appealing, the criminal, was not entitled to have self-defense issued to the jury at the guilt or innocence stage. So self-defense was not available as to liability, as to whether or not you're guilty. It's not available there. But imperfect self-defense claim warranted submission of provocation. In this case, the provocation by the clerk at the penalty phase. And then they go on to say, firing his pistol, the bad guy, the criminal, firing his pistol only after being fired upon renders applicant, the defendant, less culpable than an armed robber who kills without provocation. The jury should have been allowed to consider this mitigating circumstance in the context of the third punishment issue. Applicant's imperfect self-defense claim may have been sufficiently mitigating to warrant a sentence of life imprisonment. So basically, the way that this is reading is, it's not exactly a defense as such in the traditional sense.
Correct.
But it is a mitigation that the jury is allowed to consider, and then they can consider whether or not, and to the degree how much they care that the clerk pulled out their gun first. Will the jury care? It's up to them to decide whether or not they care, but the defendant has the right to make the argument in mitigation, not as to liability. And
Yes.
typically, when we talk about imperfect self-defense, or we talk about self-defense for that matter,
Correct.
typically we're talking about at the punishment stage, right? That's
Yes.
Kyle Rittenhouse.
Yes.
He's like, I'm not guilty of murder because, my life was under threat. I had self-defense. I'm arguing that as the liability. And so he argued that, and the jury says not guilty. Here, Texas is saying, oh, no, you can't argue it as the liability. You can't open your mouth about it, liability. They're going to convict you of murder. But if they want to use it as mitigation, that's the jury's call. That's a very interesting way of going about it. And they call that imperfect self-defense, despite the fact it's only being done at the punishment stage as opposed to the liability stage, which is also a weird way of characterizing the issue. But that's apparently the way Texas wants to roll, I guess.
Yeah, it seems like it seems, but well, before I even get into that, then we have that statute that I showed you before.
Yeah, we can bring up your screen again.
Hold on,
Or whatever it is you want to do.
I gotta find that statute. Did you the statute that?
Yeah, and I mean, if it's true for the armed robber breaking in for the purpose of committing an armed robbery, if it's true for that guy, it's got to be true for the high school guy, right? It's got to be true. Wait, he had an illegal weapon. Wait, he was trespassing. Yeah, but the armed robber gets to argue it. So surely the high school guy gets to argue it, right?
Yeah, the armed robber he gets imperfect self-defense, but no, the high school kid doesn't. Yeah. That is it. It's Texas Penal Code 1902. Let me pull that up. Sorry. Now this again, and I'm not throwing any shade at Bronco. I'm just saying,
No, that's okay. We're all here to learn.
Yeah, I'm just trying to.
This is my third try at getting the law right. Maybe the third time is the charm. Who can say?
This is this is pulled up. Let me pull this back down because this is just. Let me see if I can find a better source.
Yep.
Something because that's a little.
No, I mean it's subsection D, right? Is what you're going for there?
Yeah. So subsection D.
Yep.
So here it is.
So this is the murder statute. So the first part says this is what's murder, and then by the way, also it's a felony of the first degree. We don't like murder, but then there's an exciting part 2. Tell us about exciting part 2.
It says at the punishment stage of a trial, defendant may raise the issue of whether he caused the death under immediate influence of sudden passion arising from adequate cause. In other words, this is your imperfect self-defense. In the case of the armed robber, adequate sudden cause, somebody's pulling a gun on you, pointing at you, about to fire.
Uh-huh.
That's a sudden passion arising from adequate cause in that particular case.
Apparently.
So if the defendant proves the issue in the affirmative by a preponderance of the evidence, more than half, the offense is a felony of the second degree. That's what changes it from 5 to 99 years to 2 to 20 years.
2 to 20 years.
Yes.
Yeah, and so it's still a murder, but now it's a second degree felony murder. It's a second degree murder. It's not quite as bad. It's not a first degree felony. It's only second degree murder. That's not so bad.
Well, you can go from 99 years down to the max is 20 years.
Yeah, we go from a max of 20 99 or life, because it's any term of years between 5 and 99 or life. And so you go from a max of 99 or life to a max of 20 years. That's a hell of a discount. But it's like, but even if you can't prove it by preponderance, like it still could be mitigating, because mitigating doesn't require it to be preponderance. It can be anything as long as the jury buys it, right?
Yes.
Any amount of mitigation is mitigation. 1% is mitigation if the jury buys it.
Yes.
So I mean,
Now I do want to make it very clear. Andrew is right, and when he says imperfect self-defense is not a complete defense in Texas.
Right.
To be fair, it's not a defense at all in Texas. It's a mitigation on sentencing. It's really not a defense. It's a mitigation on sentencing. You've been found. Defense usually says I did it, but here you're taking a sentence and saying in other words, instead of getting your life in prison, you're getting 20 years.
I don't think that's quite right, and because the common law uses, it seems to me, imperfect self-defense to mean something slightly different. So I think when Andrew was citing that 1946 case, that was talking about imperfect self-defense. And also when on my previous stream, when I was talking about the 1880s and 1890s case law,
Mhm.
also talking about imperfect self-defense within the meaning of common law. So Texas basically has two kind of versions
Oh,
of
you're saying the other
imperfect.
one's a second, like that's the mitigating version. And you're talking about for the trial
Well,
version.
I'm just talking about the difference between the statute and the common law, because I think the common law is still a
Oh, you're
valid
saying there's a
thing.
common law and perfect self-defense. Yeah, yeah,
Yeah,
yeah.
yeah. So I think that, the statute is perhaps slightly different. So the statute is talking about, well, the bad guy, because in the case dealing with the armed robber, at least maybe we didn't see it in the case, but there was no physical confrontation, right? It wasn't non-deadly force, right? He didn't use non-deadly force, or did he? And then the clerk responded with deadly force. Was there a fight before the clerk pulled out the gun? Or yeah, because
Yeah.
if not, then like that would be the scenario. Like in the common law, this would be a different scenario. So Texas does it, and they don't really seem to call it imperfect self-defense. They call it instead, they don't actually use that label in the statute. So it's effectively imperfect self-defense, but they don't use that label. They
Well,
use the label for something else.
yeah, in Evans v. State, they say we specifically construe we specifically construe to include a situation where evidence arises in imperfect
Yeah,
self-defense
well, I
claim.
mean, to be fair, the section I cited also talks about imperfect
Yeah.
self-defense.
So this
So
so I understand.
the case law is messy.
Yeah, I would say there's no doubt that this is imperfect self-defense under Texas law.
Under that definition of imperfect
Yes, yes,
self-defense, it
yes.
would have to
And
be.
I'm saying this is
So
the
I get,
most
I get,
recent
so
and
I,
everything.
so I guess Texas therefore recognizes both. It
Maybe it
recognizes
recognizes both. Yeah.
it recognizes imperfect self-defense as being created by the perpetrator, and also recognizes imperfect self-defense, although the statute doesn't use that label, but the case law we just read
Mhm.
discussing it uses that label. But it's weird because it's an imperfect self-defense that isn't used for liability, which normally it's at liability. That's the way most states do it, right? You
Mhm.
would literally argue, and we saw that this week with that doctor,
Yes.
whose name escapes me. He killed his wife, dumped her in a lake near their property, right?
Mhm.
But at liability, that was the whole argument at liability. It's like the
Yes.
state says murder. He's like, no, no, no. Sudden inflamed passion. I did it because I got hot tempered, but that was liability. And then the jury returned a verdict of manslaughter based on that argument during the liability stage. Well, the way that Texas makes this bizarre is that's like, okay, we're not going to allow you to argue it at liability, but we're going to allow you to argue at punishment and basically get to the same result through the back door,
It's
which is
back.
a
It's backdoor imperfect self-defense.
yeah, it's like a backdoor imperfect self-defense that only goes to punishment, but gets you basically the same place in the end.
Yes.
It's a weird way to run a gin shop, as I said before.
But essentially that's what we have. We have this very unique way of getting to manslaughter. But I'll also say the place where I also disagree with Andrew is that he says Texas doesn't use the objective, subjective, reasonable standard.
Uh-huh.
Obviously, we see right now they do. In the case of the reasonable bank robber
Yeah.
shooting the guy,
The
they do.
reasonable armed robber. That's an interesting and exciting turn of
No,
cards.
he's at that point when somebody got a gun pointed at you, you shooting them seems pretty reasonable to me.
It wasn't a bank. It was a jewelry store. But still.
Oh my
Well,
god.
I know what I'm doing in my afternoon now. Damn.
Yeah, yeah.
Time to go rob a jewelry store, man. Damn shit.
So when Bronca says that this kid will not be able to get imperfect self-defense, I disagree wholeheartedly because I think that he can easily be convicted of the murder and argue
Yeah.
the self-defense. And I think if he's successful, you're talking about 2 years in prison and probably probation, because he's going to definitely ask for a jury to make this determination and be begging for the 2 years. Oh, I made a mistake. I didn't know. And right now, as muddy as things are, I would think, and I think that's another thing that Bronca didn't understand. Bronca, I think, was assuming that this is only going to be the judge is going to do it. Well, I don't think he understood this process on
I
Imperfect self
barely understand this
and
process.
imperfect self-defense being the in the sentencing phase, but I also don't think he really understood the fact that the jury can make the decision. If the jury does make the decision, you could be looking at a result where he could be found guilty of murder and only serve 2 years in prison, and essentially be walking free because the trial is going to take
Yeah.
about a year.
It's
Does that
still
make
murder.
sense?
It's still murder. It's only a second-degree felony murder.
It'll
So
be
it's first degree.
manslaughter. It'll
Well,
be
I mean,
manslaughter by another name.
well, yeah, it's basically what any other state would call it voluntary manslaughter.
Yeah.
But Texas calls it murder second degree, and it's like, okay, well, that's the way we're rolling. Did you have any other cases you want to share with us?
There's another. There are a couple other cases. If you guys want to
Show us some more cases. Let's go through some more case law. More case law is fun.
there's another case. This is Smith v. State, and it's a Texas appellate court case where I call it the hip pocket case. So in the Smith v. Texas case, yeah, I'll put it in a private chat so you can pull it up.
Now you can pull it up and say, I just didn't share your screen. As soon as you change it, I'll
Oh,
I'll put it back up. That's
I
fine.
gotta. All right, hold on. I'm gonna explain it, but here it is. Let me pull it up so you guys can see. Smith v. State. Let's not.
Yeah.
1976. Where's this 1976 one at?
While he's looking that up, by the way, I just wish to emphasize, as I have in every video I've discussed this, these are just speaking to possibilities.
Yeah.
What is possible, right? Is this a potential defense? Under the facts, and I've said this literally every single time, even every video I've said in Perfect Self-Defense, I've gone out of my way to say, under the facts as we currently understand them, this appears to be a bit of a long shot. But is it possible?
I don't think imperfect self-defense is a long shot, though. I think he's got a real shot at that. Because
I don't know, man. Just like, you know, a little argument that and if he had, especially if he had his hand on his knife before the first blows happened, it's like, I don't know, man. That's a lot to ask the jury to basically hand wave away, man.
But the thing is that he's going to get the instruction.
Yeah, he'll get the instruction.
That's what I'm saying. So that gives you the chance. If he didn't get the instruction, then I would get. But he's going to.
Oh yeah, no, I think he can get the instruction. Whether he can get the jury to buy is a whole nother set of problems.
Yeah. So this is Smith v. State. Now, in this particular case, this is the case in which I don't know. It's called the hip. What do I have my notes? My called the hip pocket motion. So in this case, Smith sees someone do this, the hip pocket motion, put their hand, turn their hip pocket, believes that person's reaching for a gun.
Many police officers would probably ice you at this point. So
shoots and kills him, kills it, and he says he believed it was self-defense. But the jury didn't believe it. The jury said, well, no, but in the case it was an arm. So the jury said that that no, we don't believe this is reasonable in these circumstances. That you believe that, you know, because some random person just is pulling there doing the hip. But the court found that he still was able. It still raised an imperfect self-defense argument in that case. So it was gauging the boundaries of imperfect self-defense. For instance, an armed robber in the commission of the felony gets to argue imperfect self-defense. So they were saying, well, is this enough provocation? Saying that I unreasonably thought that somebody reaching for their pocket was reaching for a gun, so that's why I shot them. The court in this case said yes. If he can argue, because again, his subjective reasonableness is up to him to argue. It's the objectively reasonable, because if it was objectively reasonable, we wouldn't be here. It would be self-defense. But since it's objective, if the argument's about the being objectively reasonable to the ordinary person, that's what he gets to argue to the jury. So, and that's what this case stands for, the proposition. So whenever you see these imperfect self-defense cases, they're really talking about sentencing and punishment. Remember, you have to kind of cop to the murder.
Is there a particular language from the decision you'd like to go over in particular?
Let me see.
Show us that beautiful legal language, baby.
Let me see. Let me get this. Let me control F it. I should have had it.
I want to control F it a lot. My joke goes underappreciated, but that's okay.
Yes. Let me see if I can find it. No, let me see. Smith v. State. It is
Oh, this is
and
a
it's
holdup.
unreasonable
Oh,
belief.
this is another armed robbery because apparently I'm reading at the top. He said he told him this is a hold up, and then when the attendant made the motion, oh, this is another
Armed robbery case.
robbery.
Yeah.
Oh, okay, armed robbery case number 2. All right, who are we armed robbering today? What kind of store is this?
Oh, hold on. Let me get
Just out of raw curiosity.
Reasonable. Oh, I'm gonna find this. Let me find this quote first because I want to make sure.
Who knew Texas was so lenient to armed robbers, man? Damn.
It's D'Angie. This is the danger.
Just
quote.
a good old boy.
I can't.
doing no
It's
harm.
funny. I can't find the quote I'm looking for, but it's because it's the hip pocket. It's the hip pocket. I know it's the hip pocket case.
No, I saw that where it's like he said, and then he reached for something. I mean, yeah, I saw where it was just like where we were before, where it said he said reach for it, and then he reached for something. I thought that's what it was saying.
Yeah.
I thought you were there.
Now it's REA. Now it's not letting me to search. It's allowing me to search again, but then it stops allowing me to search after like this. Yeah, I can't search it now.
Why not?
No, it's let me search like the first 2 letters, but then if I type more letters, it just stops.
Well, it's saying that word doesn't exist. That's why it's
No, not even words. I'm typing in like committed.
Oh, really?
And then would say committed not there.
Right.
I'm like, all right, so I think there's something wrong with my.
Maybe I can pull it up on my.
Right
maybe
there.
I can pull it up on my end then.
Yeah, I'll get it to you. Copy.
Maybe I can see. Maybe I can succeed. Let's see.
There's a link to it.
Oh yeah, you gave me the link. Okay, that's even better.
The link to it. Let me just look for it again. I'm just going to read through it. Appellate failed. Blah blah blah. Got to contentions. Where is it? There was some good language here that I
It's a grocery store we're doing an armed robbery of
Yeah.
today, by the way, in case we're curious.
This is the knife. Where is this contention?
I shot the clerk. Okay.
Well, it says the proof is clear. The appellate admits fully in his testimony that he went armed to the convenience store with his companion. So they went in armed and all this other stuff. So
yeah, the proof is clear. Appellant fully submits
Yeah.
in his testimony he went armed to the convenience store with his companion, who was also armed. And in the course of that ensuing robbery, the store attendant was shot and killed.
Yes.
And then we conclude, this is great. We conclude, as we did in a previous case, that evidence of appellant's possession of the pistol without more was not sufficient gravity to have influenced the jury heard the testimony of this brutal robbery murder. So that like that, yeah, the fact that yeah. And then where are we in this? Okay.
Perjury.
Yeah. Yeah. Okay. So here it is what you were looking for.
Did you find it?
Yeah, I think I found what you're looking for. Let me put it up on screen.
Let me take this off.
Is this right? No, this is the wrong screen. Hold on. I'll get it. Okay, this is the 1976 case. Okay, here it is. Come on. Show you stupid screen. There we go. Here it is. So we're in this armed robbery. So here's the thing, right?
Mhm.
So yeah, so we say at this point, appellant, that's the defendant, pointed his pistol at the attendant, told him this is a holdup. So at this point, our friendly grocery store robber already has his gun drawn, pointed at the grocery store clerk. When attendant made a motion behind his jacket, applicant called Robinson, who then shot and killed him. It was appellant who first pointed his weapon at deceased and attempted to kill him. It was so apparently the bad guy tried to fire his gun, but it misfired.
Mhm.
And then his co-friend shot the guy. And then, then they, left and spent the night in a house or something. And so that was the fact pattern. So this is, the gun is already drawn. The guy reaches in his pocket. He tries to fire. It doesn't work, and then his friend does the firing.
No,
And that qualifies as being able to offer that to the jury.
but just for the mitigation. I'm assuming. But in this case, the conviction was upheld because the jury was given the instruction.
Mm-hmm.
So this case was upheld. The jury was given the instruction. But it goes into the whole this I don't think the case is about he's trying to get everything overturned for other reasons. But the fact that he was given, like in other case, they weren't given the jury instruction. That's why they reversed it. In this case, he was given the jury instruction, and they didn't
Yeah.
reverse it.
So this seems to be where we're at here. So here, this is drawing that distinction between liability versus punishment stage. So this seems to be
Yes.
where we're at. So the defendant, the guy who went in with the gun and drew it at the clerk, contends that the trial court erred in submitting the murder with malice charge to the jury at the guilt innocence phase, liability. Right, citing relevant law, the appellant defendant makes claims that this type of murder, whether during the commission of a robbery or with malice, raises only to the question of punishment and therefore is erroneously submitted to the jury at the trial of the merits. So, like, yeah, there's no error because you're only allowed to make this argument at the punishment stage, not
Mhm.
as the liability stage.
Exactly.
And then in a capital case, or presumably any murder case, it was incumbent upon the court to submit the issue of murder with malice in his charge on the guilt innocence phase. Yeah. And then basically you can argue it at the penalty stage. And basically we're back to where we were, I think. I think that's what this case is trying to say.
Yes. So with these cases, what the cases are essentially saying is that there's no you have to have perfect self-defense at the liability stage to overcome
Yeah.
to get any type of mitigation. If it's not perfect self-defense, you're screwed. But even if you get hit with murder, so you'd have to be convicted of the murder. You can't argue imperfect self-defense
Yeah.
at liability. You get convicted. Then you go and the judge is now sentencing you. In that
Mm-hmm.
sentencing phase, then you can say imperfect self-defense. I really thought he was going to kill me. Then that's
Yep.
where you get and these extreme examples of people who are robbing stores, who are in the commission of felonies, they, as you can see, they even at least get this instruction. And that's where it's all playing out.
Yeah, and like the idea that it's mitigating or potentially mitigating is an idea that I don't even think that Andrew would have an objection to, because basically what is mitigating can be anything in the eyes of the jury. I mean, mitigation by definition is anything that makes the crime less worse, and aggravation is anything that makes the crime more bad. That's kind of the sort of the rough definition of what aggravating versus mitigating is. So it's like, well, I might have had my pistol drawn, but I didn't just shoot him for the hell of it. He reached into it. He seemed to be reaching into his pocket, and that's why I shot him. It's like, okay, so how much does that matter? But that's a question for the jury or the judge, as the case may be, to weigh as to how much that matters. It wouldn't really go very far with me, but he has the right to ask me how much I care before I tell him I don't really care very much.
But then let's say this though. Let's say this is in a very urban area.
Yeah.
Versus a very conservative area. You have a big this is going to really hinge on jury pool, because
Yeah.
if I'm Carmelo Anthony, of course I want the jury to do my sentencing. Of course, there's no doubt about it.
Yeah, I mean, I would imagine.
And I know this is going to
Your odds have got to be better, because you still need the jury to come back unanimously with a
Yes.
verdict on the
Yes.
sentence.
And only thing I got to show by the preponderance of the evidence is that I reasonably believed my subjective belief.
Sudden inflamed passion and all the rest of it. Yeah, and if they buy that, they might even dump it down a degree.
Yeah. So to say that imperfect self-defense is not available to this guy is crazy. It is. As a matter of fact, he will get it unless we're saying armed robbers get it, but this high school track meet kid is not going to get it in the commission of an armed robbery. So now think about how sick this is too. Even if, like, some people are saying that either he's got a weapon and because he had a weapon, that makes it a commission in a crime. You know what? Yeah. But so what?
Yeah, I mean, the self-defense statute doesn't make commission of a crime a bar to the argument of self-defense.
Well, imperfect self-defense in this particular case.
It doesn't even necessarily make it a bar in perfect self-defense the way the statutes are in. It's like the way it's mentioned in like subsection A of the statute where it deals. I'll show you rather than describe it. Give me a second.
Well, but the self-defense, it doesn't allow you to be committing a felony while committing. So, and if you can make the argument that having the knife was committing on school grounds was committing a felony, then he wouldn't have a claim of self-defense.
All right, well, let's see if I can find it. It's like 931 or 932 or something like that.
Yeah, because I know like in New York, it's like say if it's a misdemeanor, it's fine, but if it's a felony, then you have an issue.
Yeah. So like, okay, I got it. So this is 932 for deadly force. So we'll go to that. Give me a second to pull that up, and we'll walk through it. Replace screen sharing. Texas Penal Code. Cool. All right, cool. All right, so like, yeah, we're in 932, like deadly force of a person. All right, or deadly force in defense of person. So he wants to argue this. A person is justified in using deadly force against another if the actor would be justified in using force against the other under some subsection, which is 931. So that's non-deadly force. And when and to the degree the actor reasonably believes deadly force is immediately necessary. To protect the actor against another's use or attempted use of unlawful deadly force, or to prevent other imminent threats. All right, and then, okay, so we know that's definition. The actor's belief under subsection A2 that deadly force was immediately necessary as described by the subdivision is presumed to be reasonable if, right, the actor knew or had reason to believe the person against whom knew or had reason to know the person against who deadly force was used unlawfully and with force entered or was attempting to enter unlawfully with force the actor's occupied habitation. So if the person is breaking into your house, vehicle, or place of employment, right, the belief that that you're reasonable is presumed. So if you break into my house, I have a presumption of reasonability.
Correct.
So that's great, right? Unlawful and with force removed or is attempting to remove unlawfully and with force the actor from the actor's habitation or place of employment, or was committing or attempting to commit an offense described by a relevant law, right? So if there was an offense being committed, did not provoke the person who force was used, was otherwise not engaged in criminal activity. Now, this is the thing, right?
Yeah.
Was otherwise not engaged in criminal activity other than a Class C misdemeanor. But this isn't a bar. This isn't a bar, right? This is just in subsection B here, where we're at, right? This is just relating to the presumption of reasonability, right? So if it's true, it's presumed reasonable. So if you are committing a criminal activity other than a Class C misdemeanor, right, it's not presumed to be reasonable. It's not presumed to be reasonable, but it doesn't mean that it can't be reasonable, right?
Yeah.
Because then they get into like, if a person has the right to be present in location, is not required to retreat. So that's, stand your ground.
Yeah, but
then whether it's believed to be a finder of fact may not consider whether they failed to retreat. So yeah, actually committing a crime is not a barrier. It just means that you're not presumed to be reasonable, but you can be committing a crime and still argue under 932 the way this is written, unless I'm misreading it.
You'd be presumed reasonable.
Oh. Yeah. So I mean, you're not presumed reasonable, but maybe I can still get there.
Maybe still argue
because I can still get there.
I've seen because even in the Evans case, the first case there's a piece in there that specifically says if you're committing a felony, in this case robbery, self-defense is not afforded to you under the law. So look at Evans.
But okay, so I mean that's not what 932 says, but let's take a look at Evans and see what it has.
Yeah, but Evans and to be fair, Evans could have been before. Well, Evans is 1980, so I don't know if it's. I don't believe.
I seriously doubt this is an issue of predating the relevant law.
I
mean, this current version is to be fair. I mean, this was done 1973 in its original version. I have a hard time believing it changed in this way, so I'm not going to assume that for the sake of argument.
I just wanted to put it out.
But show me what you're talking about, or put it on screen and
let me see if I can.
If Evans says the commission of a felony precludes you from being able to offer this defense. as to lethal self-defense. That might be true. I mean, maybe there's case law that says it. I mean, that's why we have case law. The statute doesn't seem to say it, but maybe the case law does.
All right, here it is. I'll share screen.
I got it.
So now this is working again. I can do 4 letters. All right. So it says, according, oops, let me blow this up more so we can see it. According to applicant's confession, before he fired the shots, the manager of the jewelry store pointed a pistol at him and fired it because the appellant entered the store with a pistol to commit a robbery. He has no legal right to self-defense against the
Fair
man.
enough.
Davis v. State, blah, 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 Texas v. So they have multiple citations for it. So yeah, so if you're trying to commit a felony in Texas, in a commission, you have no
Well,
right.
at least a robbery, but yeah. So
No
at least
legal
at least some felonies, it is apparently a bar. So I stand corrected. It's not. I mean, the way I read the statute, it's not there, but that's what the case law says. So fair.
All right. Well, so I would say, well, with all this, you know what? Let's go to check this one out. So let's look at Andrew, because I pulled up his thing. Let's look at what he said.
In the Texas version of imperfect self-defense, we're not really looking at objective reasonableness. Instead, it applies in the concept of a defender who was an initial provoker of the fight, a non-deadly force fight, and then finds he has to kill in self-defense, and he kills that other person.
Mm-hmm.
So it's a consequence of someone, the defendant at trial, the killer. It's a consequence of a killer who provoked the initial confrontation and then had to kill. So,
but now, the interesting part about this is that our robber,
Mm-hmm.
this would fit his situation. He provoked the situation, and then he's got to use deadly physical force because the guy's about to kill him.
Well, I mean, the one case I cited, that 1946 case from the Texas Supreme Court, seemed to say that if you provoked with the intent of using deadly force, that would be a bar. That was one of the sentences in that 1946 case.
Okay.
So, yeah. So in the case of our armed robber friend who went into the jewelry store and drew his gun on the manager and is pointing at the manager, it's like, well, I think you're going to have a problem being able to be like, I didn't intend to use deadly force, right? Like that's that. If that's not provocation with deadly force, it's like, I don't know what it is. So it would seem to bar the argument for imperfect self-defense under that law, but that would be an argument as to liability, and you can still offer it at least in mitigation at sentencing. So, because to be fair, it is less bad to point the gun at the clerk and point the gun at the clerk and shoot him because he reached for something versus pointing the gun at the clerk and just shooting him for the hell of it. Pointing him and shooting at the hell for it is more morally bad. I think we can agree on that.
Yeah.
How much that should matter in terms of the punishment, if at all, I is a question for the jury to figure out. I'm not sure that they have much sympathy with me, but that's me.
let me make it a little more concrete. Imagine we have Joe. Joe provokes a fight with Tom, but he's intending only a non-deadly fight.
So this is the imperfect self-defense that you guys are talking about. So this is a common law self-defense.
Yeah.
That would apply to the liability phase, or the not the penalty phase, I call it liability phase, but the
guilt phase.
The guilt phase of the trial. The guilt phase before. So this would get you manslaughter instead of murder as a technical piece of it, right?
Yeah, it seems like that's the way that makes
Tom's
sense.
Pulled out a knife. Joe can claim imperfect self-defense and mitigate what would otherwise have been murder down to manslaughter.
Mm-hmm.
So this is the way up to 1945. So and he goes into it, right? The 1945. He talks about the 1945.
It got my attention when he cited it. I'll tell you that.
To Marcello Anthony. And here's just a cite from a Texas case. There's not a lot of Texas law on this, by the way. And it's
but his research skills aren't really that good.
Well, I
There's
mean,
a there is some Texas law
I mean,
it.
to be fair, like you found one case on this issue, but there doesn't seem to be like a lot. There's not like a
There's
legion of cases.
there's I'll say how many cases was I able to find? I think I found like 6 that talked
Okay.
about imperfect self-defense. A lot of them were just like were just like it was mentioned in a passing, or
Yeah, that
I
was a
found
lot of the problem I
some
saw.
I
Yeah,
found
it was.
some that were mentioned in the well, there are 2. I found a whole bunch of cases that mentioned imperfect self-defense, but let's say in a footnote and stuff. Then I
Yep.
found some that introduced it in this context where, hey, like the jewelry store, the grocery store, and there were a couple other ones like that. The more recent one was the Amber Geiger case.
Mm-hmm.
That was the Dallas
Sure.
police officer who walked into the apartment and shot the guy.
Yeah.
Well, that was murder because she didn't get self-defense, but
Yep.
then the jury mitigated it to imperfect self-defense. That's why she only got 10 years instead of the 90, the
I
life in
don't
prison, right?
think that's true. I don't think they did mitigate it, but I think they sentenced her to 10 years nonetheless, because the sentencing range for first degree murder is 5 to
Oh,
99.
5 to 99, yeah.
I think they just picked 10 because that was the number they thought was warranted. I don't think they actually mitigated it down.
Did she because she did argue.
Yeah, she
She
did.
did argue well, in other words, you know what? So let me say this. She got the instruction about mitigation for imperfect self-defense. She
I'm
had
sure
to be able to
I'm sure
argue
she
it.
got an argument as to mitigation. I'm sure she
Yeah.
got that.
Whether the jury bought it or not, that's yeah, because they could have given her 5 years. I think it was 5 to 99. So I
It
think
was.
she did get murder, yeah.
Yep.
So yeah,
I thought she got out of out of that about as good as it was going to get, because her attorneys were talking about appeal, and I'm like, no.
yeah, I don't think she did. I don't think she
No,
did.
you don't want to appeal this. It's not going to get any better.
It's the Court of Criminal Appeals. That's really the Texas Supreme Court for
It is.
criminal matters.
Texas
Texas
is weird.
kind of weird. Oklahoma
It
does this
is.
too. It has 2 different Supreme Courts.
I don't know why.
One for civil matters, one for criminal matters.
Yeah.
But this is from that court, 1945. There's not a lot of case law on imperfect self-defense in Texas.
Yeah, because he says that. Let me see. I even have to look at a little case chart.
I mean, when I did my research, I found the same problem as you. I found a lot of cases that talked about in passing and didn't really describe it. They just referred to it and said, "Oh, there's a common law thing," but they didn't really describe it in any detail.
Yeah, the last one was the
Maybe
Amber
it's
Geiger.
so well understood, no one actually needs to mention it.
Well, I think yeah, because I'm assuming because I'm assuming everybody gets that thing anyway. So it's like okay, if you think the armed robber was justified, if it mitigates it somehow that he shot the clerk because he was going to get shot, so it's probably like a nothing thing. The jury instructed the provocation. Yeah, because even Smith C. State, I got this other one, Stoudemire, where he killed his wife, believing that she was going to unlawfully use force against him. Reasonable, yeah. So I can see that, but this case is not the most recent case, though. It's the 1980 case. I think the Evans case is more relevant, and I think even Amber Geiger is probably even more relevant to that. Recent than
Texas. But it reads, imperfect self-defense arises where the accused, the defendant, the killer, provokes a difficulty not with an intent to kill, but merely to make an assault, to whip, beat up the assaulted party, but that by reason of his own acts and conduct, he was driven to resort to extreme measures in killing the party he had provoked into a difficulty in order to protect himself from death or serious bodily injury.
So this is where you guys stop, right? And said, okay, this is imperfect self-defense in Texas.
Mhm.
And based on what he's just saying, I don't think this would be available to this other kid at all. To the kid that we're talking about.
Well, not under this theory of imperfect self-defense. No, that's exactly what he was saying, and that's exactly where I was, going to. But then you had that case. I mean, in the case that you read talks about imperfect self-defense. It uses that language. So I mean, yeah, I don't know whether or not the court was. I suppose to some degree it doesn't really matter, because at this point we're just arguing about the label versus what it is. So it's like, does it really matter whether we're calling it imperfect self-defense as opposed to what it is? It's like, does it matter if we call it imperfect self-defense, or does it matter if we call it, okay, no, it's, it allows you to argue that if there's sun inflamed passion, now it's only second degree murder, but is that the same thing? Does it matter what we call it? I'm not sure it does anymore.
No, it doesn't. I think now we understand. So when those law firm websites had imperfect self-defense, they're describing it in a way in which it seems like they're talking about mitigating
Yeah.
from the guilt phase. But if
Yeah.
you look into it, they're actually talking about mitigating from the sentencing phase.
Right.
Yes.
And so I think that's at least partially the confusion because again, as we mentioned, typically when you're doing this, you're doing it as to guilt. You're doing it at the liability stage. Like, did you do the
Correct.
thing? And the state is saying, no, you did this. I'm saying, no, I didn't do it. What I did was only a manslaughter, you know? And we saw that with the doctor, exactly that. During you know, the jury's like, okay, is he guilty of this or guilty of that? They're given to it, they're given in the alternatives. Like, do you like this reason or do you like this reason? Which of these reasons do you like best? But in Texas, they seem to be doing again on the back end, which is, you know, so that's imperfect self-defense is not strictly a defense in guilt. It's a defense in punishment, even though it kind of gets you to the same exact place in the end.
Yeah, I do think it's also unique too. I think it's hilarious that in these extreme situations, they give you this imperfect self-defense. It's like, oh, you can still
Yeah, I
argue
mean, you
this.
know, if you're able to argue imperfect self-defense during the armed jewelry store robbery, right? If you're allowed to argue imperfect self-defense, then there's no way that you're not going to be allowed to argue it for the high school track. Oh, he brought a knife with him. Oh, he was at a school. He wasn't allowed to bring the knife. Yeah, I was like, yeah, but you know, it wasn't a jewelry store armed robbery. So
It wasn't a jewelry
probably can
grocery
still
store,
argue it.
grocery store robbery. When you try to shoot the guy, your gun jammed.
Oh, by the way, it's also worthy of noting because this is also interesting on this as a technical point. This means that he can choose to take the stand only during the penalty phase, right? If he wanted to. So because this is a penalty phase only argument, right? Actually, in some degree, depending on your point of view, I don't know whether it's more defense friendly or not. I have to actually think about it. But normally, right, if you're arguing this in liability, right, normally you'd have to be like, the state says, oh, no, it's murder. And you're like, no, it's really manslaughter. So like, well, how are you going to prove that? You know, because typically you're the only person there, right? So it's like you're going to probably have to take the stand. So you're going to take the stand in your guilt phase. But, you know, once you take the stand in your guilt phase, the state gets you ask you all kinds of exciting questions, you know, relating to the crime and all kinds of things. It's a hell of a risk, but it's actually arguably better for the defendant this way, depending on your point of view, because in this way, the defendant doesn't have to take the stand at all. He can just, or at least during guilt, he doesn't. He can let the state be like, it's murder, 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 murder all the way wrong. He can keep his mouth completely shut. The state and the you know, the jury comes back, how about murder? And then he's like, wait a second, I have exciting testimony I'd like you to consider. And he can do that because, you know, there's new evidence taken during the penalty phase.
But the problem, the one thing I think you're missing is that the rules of evidence in the penalty phase are a lot more relaxed.
They are a lot more
So,
relaxed too. So we can get into
hearsay.
yeah. So we can also get into hearsay. We can get into prior bad acts. We
Yeah.
can get on all kinds of things that we So it's like, isn't it true that you're
It's
a
a risk.
miscreant? Isn't it true that you're a miscreant and did a whole bunch of other bad things?
Did
Isn't
you
it
bring
true
up?
that isn't it true that you're a bad person and a threat? Yeah, you can get into all kinds of stuff. You can't. So as he takes the stand, now I get to ask him all kinds of questions I wouldn't be able to ask him in the first place.
Yeah.
All kinds of fun things. So it's an interesting ride for everybody, I suppose.
Yeah, yeah, that's gonna be crazy. So, what do you think now? Because our first prediction before this whole imperfect self-defense thing
Yep.
corrected. Now, I think we kind of have a good idea of what it actually is now. Based on that, I honestly think I don't think this kid's getting 99 years. I don't think.
I don't think so. I don't think he's going to get. I don't think they're going to max him out.
I'm thinking it's going to be the
Yeah. This is not the worst of the worst. I don't think they're going to be looking to throw the. But I think he could wind up getting a couple decades.
Yeah, I think it all depends on the jury. This is a jury selection case if I have never not seen one.
Yeah, I believe the jurisdiction's about evenly split, Republican, Democrat, isn't it?
Yes, and again, if you're talking about mitigating factors, and if we're talking about imperfect self-defense being raised, which he would be a dummy not to raise, right? I would go self-defense and imperfect self-defense if you.
But to counter something you said a bit earlier, this isn't necessarily a right-left issue because Andrew Branca has had to fight people on his own chat because they're so conservative that they believe merely being touched should be sufficient provocation to pull out my pistol. You know, that's some of the people in Bronca's chat have said that. And Bronca's been like, I know you think that should be true, but you know, just because you're touched doesn't necessarily mean you can pull out your pistol. We're not necessarily doing the old West days. So I mean, there are some hardcore people on the right who might be like, nope, he was touched. Fuck the guy, you know.
Tim Pool.
Yeah, Tim Pool. So yeah, this isn't necessarily a right left necessarily clean divide.
Yeah. No. But that's what I'm saying is that though. That's why I believe jury selection is going to be really tough, because generally you can kind of pick, this guy's a conservative, you're going to think this way. Here, if you got Tim Pool on your jury, you're probably going to win, because Tim Pool is out there saying, hey, he's saying the hip pocket guy. Somebody goes hip pocket to me, I'm going, they're in trouble. They're in trouble, right? Or what did he say? He said that if I go hip pocket and tell you, put my hand out and say, hey, don't come any closer. Don't come any closer. And your move, is that self-defense? You know, you come and grab him. Is that self-defense? You've got clear warning. So I really, it's arguments obviously, but I do think I honestly don't disagree with the decades. The one thing I think we're back to where we were at before.
I think fundamentally we're back at sort of like no matter
this will be a manslaughter
no matter
sentence.
Sort of no matter where you sort of wind up on this issue, we sort of wind up back at sort of the end game, because it's like, even if, you know, it doesn't work as to, you know, changing the charge, it's still a range of 5 to 99, which is one hell of a range. And so then it just becomes up to the jury to decide what the appropriate range is, taking into consideration everything that there is to take in consideration: the guy's age, you know, that they're hot with testosterone, the fact that this was a fight, you know, especially a penalty phase, any sort of bad blood that might have pre-existed either way, a whole bunch of things. And so someone's going to have to debate amongst themselves what number seems like best number.
Yeah. And I also think it is going to come down to this, because
as a judge, I think I'd much rather have the jury do the sentencing. I'm like, are you sure you don't want the jury to decide this? I think I want out.
I think the fact that there are so many people, right and left, who are arguing that warning, touch me and see what happens, that even if you do get a conviction for a thing, I think it's enough that he's going to get, because don't forget, he's got to just prove his reasonableness beyond the preponderance of the evidence. He's not got to, you know, that's a real low standard. And I think I think a lot of people believe that he was being reasonable. And if you have that, I think you're screaming manslaughter conviction. I'm sorry, murder conviction with the manslaughter sentence. That's what I think is going to happen. And I think you were there before. I think if perfect self-defense was in the guilt phase, you'd be saying manslaughter. But since it's in the penalty phase, it's like I think you're still sentencing a murder charge. Are you still believing he's going to be sentenced for murder or manslaughter?
I mean, my prior analysis was basically, I thought it was a relatively thin defense based on the information that's currently available. So I don't think I would tend to based on what we presently know, I don't think that I'd be inclined to say that this is a provocation, a sudden provocation that, for my mind, triggers that subsection. You know, that subsection, like the quintessential case is the husband who walks in on his wife and their lover, you know, pulls out his gun and shoots one of them, right? That's the quintessential case. The sudden inflamed passion, you know, a thing that puts someone into a rage of such description that, you know, basically we understand that you were in a rage. It's reasonable for you to have been unreasonable. That's basically, it's reasonable for you to have been unreasonable. And so we're going to give you a bit of a partial pass. But like, to my mind, this current situation doesn't really lend itself to that. It's broad daylight. You know, we're not in a confined space. There's lots of people around. If he needed help, he could have asked for help. He wasn't like, you know, there was some impetus, there was some words being exchanged, there were some tempers, but I don't think we're quite into that territory. So I'm not sure I find it by preponderance, but maybe that's just me.
Let me read. This is the section I was talking about earlier that I was trying to
Excellent.
Find. When another male who he did not know walked over and sat under the tent. This is after the rain started, obviously. Then Austin, the victim, told the male that since he did not go to memorial, he had to leave the tent. Austin and the male went back and forth, and then Austin stood up and pushed the male to get him out of the tent. So that was the first interaction. He pushed him, get out of our tent, right? Blank had said during the time of arguing, the male reached into his bag. So this is after the push.
It
Reached
looks
into
that
his
way.
bag,
Yeah.
and it was at that time the male took out a knife and stabbed Austin.
I mean, I think it's something as simple as whether he reached into the bag first or not is going to be a huge issue. It's like if he reached into the bag before, any hands came on, I think that's more morally culpable than, if there was some fighting around and then he reached into the bag and then, it escalated from there. So, the exact timeline is going to be a huge factor.
And I do think this gives you more ammunition to mitigation or even self-defense, because here you are saying the whole he was pushed first. Now you have an assault happening before the whole push me again and reach into my bag. It's not just like somebody just said something, you reach into the bag. It's now you're being pushed and there's a back and forth. So you have a witness here saying there's a back and forth, there was a pushing, he reached into his bag and said, touch me again, blah, blah, blah. That's a different scenario now. And I think that now, I think my prediction on mitigation is I'm more confident in it because if these facts want to be true, because this is the police report. These are what people are saying at the scene.
Yeah, it's not even the witness statement. It's the police's write-up of the witness.
With the hearsay. This is obviously hearsay.
Yeah, it's hearsay, right? Yeah, it's like, and what exactly does that mean? I mean, there's something like 40 witnesses. There's got to be video of this. So there's probably multiple videos of this. So we there's a lot. Even the government doesn't have a complete picture at this point. I'm quite positive. The police investigation, I'm sure, is still going underway, trying to interview these witnesses, going through the video. They're not even close to being able to understand what really is going on. And that's the government. They don't understand what's going on yet.
Yeah, because I think that it's very muddy, because like just my reaction to what I believe happened. Again, I don't know anything about I wasn't there, but but what I believe happened is that you had two teams who are competing in a track event right there, right? Pouring down rain starts. This guy jumps under the tent so he doesn't get rained. The other guy sees him. They say, hey, what are you doing here? Just like you say, what are you doing here? Get out of here. The guy's like, it's raining. And the guy starts pushing, get the hell out of here. I don't care about the rain, right? Pushing him. This other lunatic then goes into his bag and pretend, oh, if you touch me again. That, I think, is crazy. And then then the guy, being Mr. Macho, all right, touch you again and see what happens. Here's the touch. This guy stabs him, and then now you have this whole situation. Now, what I've just described to you, I believe, is 100% manslaughter. I believe that's no doubt about manslaughter. I do not think this guy is justified in stabbing somebody for touching him. I don't.
You're weak. You're weak.
I'm just saying, I don't believe that response is appropriate for someone who is not armed, who's just pushing you and so forth. That is not enough for deadly physical force.
No, of course it's not.
It gives you enough for physical force, right? To if you want to push him back or something, but not deadly physical force in that. Now, I know some people, for instance, were saying, well, hey, in this case, or they say that I'm being racist against black people because they say in this particular case, the victim was pushed beforehand, as you just saw. The victim was pushed beforehand, before he employed deadly physical force, gave a warning, and then struck when the guy tried to hit him again. They'll say, well, when it was in Daniel Penny choked the guy, and he hadn't touched anybody. He hadn't assaulted anybody. He was just giving verbal threats.
In the
subway case.
Yeah, the subway thing.
And they say that we're being inconsistent because in that particular case, the threats didn't arrive to anybody being touched. And we believe that he was justified in employing physical force that turned into deadly physical force in that case. But in this case, where the guy is touched and gives a warning and is touched and is grabbed again, we don't believe that they have an argument for deadly physical force. How do we square that circle?
Well, I mean, you could potentially square it on the idea that although death occurred, it isn't necessarily deadly force, because deadly force doesn't mean death occurred. So therefore, maybe if death occurs, it doesn't mean deadly force either. Maybe it's non-deadly force that results in death. I mean, that's possible, right? At least in
Yeah.
principle, right? I mean, I just punch you and it's non-deadly force. And like, I take the victim as I find you, but I'm still like only, it's like if you have a weakened condition, but that's only if I was liable in the first place, right? So if like I have no excuse and I punch you and then, you die because of some aberrant condition, then I'm screwed. But if I have cause to punch you and I punch you and you die from some aberrant condition, no, I still have a valid defense because I didn't exceed my lawful bounds. Your weakness, the weakness doesn't mitigate my, doesn't prevent me from being liable. But if I'm not liable, the fact you're weak doesn't prevent me from using the defense. I'm pretty sure that's correct. I think I said that correctly.
You see, I think about it a little bit differently.
Hmm?
The threat of deadly physical force, you can respond to the threat of deadly physical force with deadly physical force.
Sure, of course.
Right. So if someone is coming, walking at you, I'm going to kill you, and raise their hand, and you can respond to that threat of deadly physical force. In the
Mhm.
Daniel Penny case, he was responding to the threat of deadly physical force. The guy was threatening to kill everybody in the train, acting erratically, lunged at someone before they grabbed him. And there were other people there acting reasonably who did that. So that response to the threat of deadly physical force and I'll even go as far as to say with deadly physical force is appropriate, right? Because you were responding to deadly physical force, or as everybody in the train car testified to, they perceived it to be deadly physical force. And so everybody, he was going to kill us. We were afraid for our lives. That deadly physical force. In this particular case, no one except for the perpetrator believes that that Austin was going to give was deadly physical force. So, for instance, pointing and just poking somebody, that's physical force, but that's not enough to do to shoot me.
No.
So I think yes, the threat of deadly physical force is enough to get you killed, but also you can have physical force, like you were just saying, that doesn't arise to that level. So that's what I think. But that's the argument. And the second argument that are out there, when it comes from Daniel Penny, is that it was the not the Rittenhouse case. It was another case where the person, Trayvon Martin.
Yeah.
And Trayvon Martin, fisticuffs, punching a guy, and we all said that George Zimmerman was reasonable in using self-defense in that particular instance, and in this particular instance, we're saying that it's not, and we have pretty much a similar thing. One person is armed, the other person accosts the person, and then all of a sudden the guy says, get off, yells a warning. George Zimmerman yelled a warning, get off me, and then had to shoot the kid. This guy yelled a warning and was attacked too. And George Zimmerman, we're saying self-defense.
I think in the Zimmerman case, the evidence allowed for the conclusion that it was deadly force. Because all we had is Zimmerman's testimony about exactly what happened. But as memory served, it's been a while, but as memory serves, he was on the ground and he was being punched on the ground and all the rest of it. So like his conclusion that was deadly force was a lot more viable than in this Texas situation, because the situations are different.
Yeah, well, I would say the only thing that would get, because the Zimmerman one I have more trouble with squaring, just on because it's not to me clear how separate they are, except for the three things I do think about in the Zimmerman case. It's at night.
Yep, that helps a lot.
You think he's a prowler, and he's on top of you, punching you.
Yeah,
trying to, so I'm assuming, and you're screaming, help, help.
And there's no one around to save you. There's like you're isolated.
Yes,
it's a different factual picture.
It's a different factual picture. So, and he was already being pummeled by the guy. So this wasn't he was already being pummeled by the guy. So in that sense, I think in the George Zimmerman case, I think a lot of people fail to realize that was another of the case of both parties were right in using self-defense in the way they were using it.
Maybe, yeah.
I think Trayvon Martin was justified if he would have killed George Zimmerman in self-defense because you have a guy following you around, looking at you. You're scared, then eventually he catches up to you.
Yeah, maybe.
And if he
maybe.
kills the guy right there because he's a teenage kid being followed by some grown man, I would say he was justified in
a
self-defense.
grown man who had a gun on him. As it
Yeah, I
happened.
would say he was justified in self-defense.
Yeah.
But then, from Zimmerman's perspective, it's like, I think this guy's a prowler. He gets the best of me. He's beating you. Then I got self-defense too. It's the same thing in the Kyle Rittenhouse case. You had the
Gage Gershkowitz.
Yeah,
Yes,
he
like
shot
if
Kyle,
if
he
Gage
wouldn't
Gershkowitz had shot Kyle Rittenhouse, as like I've said this before, Gage had a plausible defense of others argument.
Oh yeah. No, I think he gets off like Kyle Rittenhouse. I think he gets off.
Maybe.
So I say that to say this is that when you add race to it, I think people are just want to believe that these sets of rules apply the same in every situation, and they don't. A track meet at a high school is different than the middle of the night in a neighborhood in Florida.
Yeah, why
right?
wouldn't it be? But why wouldn't it be different?
But I'm saying, that's why. So I don't think I'm being inconsistent in the way I'm applying the law. I'm just being consistent in the way I apply it to different circumstances. And unfortunately, in the Trayvon Martin circumstance, I thought for many years that was a murder. But then when you look at the situation and look at the photos of Joe Zimmerman right afterwards, like his bloody nose and everything, you would see he was literally in a life and death situation. I would have shot, unfortunately, probably Trayvon, but then on the back end, if Trayvon would have killed him, I could honestly see that happening too. So I say that to say this.
So no one's happy now.
Yes, but I say that to say this. In this particular case, I do believe there is a viable claim.
I agree it's viable. How viable is a whole nother set of problems.
That's where
viable. I will give you.
Yes, I would. Now, what do I think he'll be arguing self-defense in this case? Yes, I think you would be a fool not to argue it. I think the arguments, the issue is going to be proportionality. I think no matter what, no, I don't care what anybody else is telling you. It's going to be
proportionality is probably where this thing breaks.
That's the name of the game. What I mean by proportionality, for those of you who are not lawyers, is just that, was his use of deadly force appropriate for the force that was applied to him from Austin? And that's going to be the issue. And this pushing of stuff before and all that stuff, all that's going to make it seem like, hey, he was warned, he was pushed before, that type of thing. Then on the back end, I think he has a second bite at the apple. And I think that second bite at the apple, if he's convicted of murder, he's still going to go in there and say, well, guess what? I have imperfect self-defense and it should be manslaughter and give me 2 years.
Could be. What's the probability we come out of this thing with a verdict that makes everyone happy in the end?
None. Because I think he may be able to get to self-defense at the punishment phase. Not at the punishment phase, at the guilt phase.
Yeah.
I really think if you get the right jury and the right arguments, I think you can get to self-defense at the punishment phase, at the guilt phase. I think it's a long shot, but I think you can get there. Then I think even if you miss this, I think the most likelihood is that you'll get a lighter sentence on the back end.
All right, let me read a few super chats and fun funding that came in. For Dorgy More Corgi, great name, love it. Became an uncivilian. Elf Pre-Eva became an uncivilian, has been a member for a month. New York Renal MD, longtime supporter of the channel, 39 months. $5 from Elf Pre-Eva. We also have to remember this was a K through 12 school, wasn't it? Well, yes. Mm-hmm. Why in the world did the boy have a knife in his backpack at school? Well, I don't know how unusual that is necessarily in Texas.
Yeah, but, Texas is different.
Yeah, I probably... Just notwithstanding the legality of it, if you told me that there was a non-inconsequential number of people with knives in their pocket or backpacks at school, I think I'd believe you.
And just want to make it also clear, it's the length of the knife is also important too. If it's if a very short blade knives are actually legal. It's the anything over 5 inches or something like that.
Yeah. Yeah, that could potentially change things in some ways. New York Greenland MD for $2 says if he takes the stand, can't he argue self-defense? Yeah, well, we discussed that. He might be able to split the difference. Alan Parker, a very, very long time supporter of the channel, indeed, gifted 20 gift memberships.
Oh, nice.
Bibliophile gifted 20 gift memberships. $5 from Pin King 554. Most of this should be voluntary manslaughter, not second or first degree murder. Well, it might be second degree murder, but it's really voluntarily manslaughter by another name. So the label may not be the thing.
That's funny. Oh, that was the last super chat?
Yeah, that was it.
But you know, it's so funny because you think you know the law, and then you get some quirky issue like this, where it's like, hold on, it is, but it isn't. But the way they do it is just so weird. Like most other states make this very simple. Well, we'll give you manslaughter. You know, it's like, well, we got to go through this whole thing. Well, you're really a murderer, but we're going to sentence you like you're a manslaughter. It's like, what the hell is this?
Yeah. Of course, there's also the possibility of a plea deal, which I'm sure would piss everyone else off too. So, but that's probably not our near future.
But the plea's got to be to, well, I would even say maybe an involuntary manslaughter, because you're talking the only real good. Yeah, I think you're talking about maybe a manslaughter or involuntary manslaughter. It's the only thing you can do for a plea.
It doesn't distinguish, you know, manslaughter is manslaughter. So
Yeah.
it's the same sentence either way, whether we call it involuntary or voluntary, it's the same.
Yeah. Well, with that being said, what do you got coming up, bro? I'm about to go out there and watch this movie.
So coming up, starting give or take Tuesday, we have, of course, the Karen retrial part 2. Should be exciting. Part 1 was exciting with the stupid, and part 2 should be even more exciting with even more stupid. Plus issues still ongoing as to who can testify, including whether the ARCA experts can testify and to how much and so forth and so on. So we're still doing evidentiary voir dire issues as things go, and it's going to be fun and exciting. So make sure to tune into my channel for that, and we're going to have fun every single day. Please bring popcorn. What you got coming up on your channel, Nate?
I got the undocumented woman who became a city councilor. She's pleading guilty and going to resign. So I don't know if I'm going to cover that right now or wait. Then I have the judge who shot her boyfriend in the head. She was just convicted, but then it was like another. But this is like her second time shooting her boyfriend in the head.
Yeah, it's like if you've shot 2 boyfriends, it might be you.
And there's this. I'm gonna shoot the screens. And there's this which I'm going to be going over now in the context of this case, because I was going to write a response to you and but just going over what I had found. But and I think you may want to react to this. So this is a show called Face Off, and they're arguing this case. But the interesting part about it is that you got to listen to this. This guy. This
guy has a look, man.
Well, let me. I want to show you something. How crazy this is go. He says that this is the new Rosa Parks because
I mean shoot for the moon. Damn.
Yeah, this is Rosa Parks. I don't know why I'm giving you guys up all the good stuff, but I'm gonna give it to you now.
Your seat?
So he says because he was asked to give up his seat.
Wow.
The white man asked him to give a seat. This is a fight for Rosa Parks. No, I'm not joking. Here it is. This is the opening to the video, by the way, too. So check it out.
That's what needs to be taught here. And to tell this young brother to give up your seat, give me your seat. This ain't no damn Rosa Parks era. You just can't go to a young black man and say, give up your seat. He had a right to sit there. And so that brother had his back of the bus moment and refused to give up his seat, and it cost that young white kid his life.
That is, in my humble opinion, a fairly aggressive way to characterize this situation. Wow.
You see what my videos do well. You see why my videos do well. This guy says he's Rosa Parks. Give up my seat.
It's worse than that. It's the painting behind me. It's the schoolgirl being taken by the marshals in New Orleans. It's her. She has to be taken by the marshals as they're integrating the schools. Man, woof.
Yeah, it's crazy. But that guy could be on your jury. That guy could that guy could be in your jury because the jurors don't go and say it. I have these. Oh, he be thinking, yes, I can be fair and impartial. Back there thinking, this is the white boy on the move. This is Rosa Parks.
The only thing that surprises me is that he
Jury
didn't.
selection is important.
He didn't
brother.
in that say it was a lynching. That's the only way that this can get more aggressive.
Yeah. But now it's interesting because because I was, I'm fact checking both sides, trying to fact check him. That's where I found out that there was actually the assault occurred before he put his hand in the bag, as the witness statement
Maybe,
said.
possibly.
Well, I'm thinking because all the information I know is from witness statements through hearsay. So the fact that he was even, I know that from witness statements through hearsay. So right now, giving the witness statements the credibility because I have them, if I'm going to give the credibility to the witnesses saying that he went in his bag and grabbed it, then I have to give that same credibility to this witness who says, yes, I was there. He pushed him before he went into the bag, and then he went into the bag, and then they had a little tussle.
I'm definitely going to have to do a response to this video later today. I think it sounds like a fun video for me.
You haven't even begun to get into the craziness. Like it gets so insane. That's why I was like, I got to respond to this. Is like insane. It's so insane because essentially when he said, obviously he's making it the full self-defense, but his self-defense thing is that and he's the one that brings up a lot of the whole thing. When you're talking about Rittenhouse, when you're talking about these other cases, what about this other black guy who was shot without, but this guy says, but it's another black guy who was shot without, unarmed by a white guy. So they go through all that. But, I say this to say, I say that to say this. My legal analysis, I don't really care about the color of the person or what happens. I really care about the facts in front of me. Like, to be honest with you, I don't even the fact that this is black or white, but it's so fascinating that everybody else does, to the point where this guy, the black guy in this thing, would be saying something totally different if the skin colors were reversed.
No, he probably wouldn't be analogizing the white guy who refused to give up his seat to Rosa Parks. He probably wouldn't be making that analogy.
Yeah. So, well, listen, with that being said, let's get out of here, bro.
All right. Well, friends, thank you for tuning in for this exciting thing. And thank you to my guest, Nate the lawyer, for his contribution to this party. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.